The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome to the docket of the Kansas Supreme Court. I'd like to welcome everyone both on the call as well as those who are watching on our Supreme Court Live channel. I would also like to introduce and welcome our visiting judge today. Judge Bruce Brown is joining us. Judge Brown is sitting in the seat vacated by the recent retirement of Justice Carol Beyer. Judge Brown is a district court judge in the 18th Judicial District in Sedgwick County, Wichita, and he has served in that position since January of 2009. Judge Brown, we are thankful that you have been willing to take time from your own docket to help us today, and we are honored to have you join us.
Thank you, Chief Justice.
Certainly. With that, I would now ask Mr. Doug Shima, the clerk of the appellate court, to call this afternoon's 1:30 docket.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Monday, October 26, 2020 consists of two cases. The first case is appeal number 122867 in the matter of Ogunmeno I. Ogunmeno, original action in attorney discipline, no briefs filed. The second case is appeal number 122332 in the matter of Amy J. Aarons, original action in attorney discipline, no briefs filed. For the first case, the disciplinary administrator has reserved 2 minutes time for rebuttal. Your Honor, we are ready to proceed with appeal number 122867 in the matter of Ogunmeno.
Thank you, Mr. Shima. I would ask now that you please enter your appearances.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office.
Mr. Ogunmeno, go ahead if you would enter your appearance, please.
May it please the court, this is, my name is Adebayo Ogunmeno.
Mr. Vogelsberg, you may begin your argument.
Thank you. This is an original proceeding in attorney discipline involving attorney Mr. Adebayo Ogunmeno. Mr. Ogunmeno was admitted to the Kansas bar in 1991. Sometime in June of 2018, Mr. Ogunmeno left the United States and went to Nigeria. At the time that he left the country, he had 4 legal matters that were either pending against himself personally or pending against his clients. First, he had an appeal pending before the 10th Circuit where he was challenging Federal District Court Judge Julie Robinson's decision to personally sanction him for violating Federal Rule 11. In August of 2018, the 10th Circuit affirmed Judge Robinson's decision. Second, Mr. Ogunmeno had an appeal pending before the Kansas Court of Appeals where he was challenging a judgment of $38,800 against him for legal malpractice. Mr. Ogunmeno failed to appear for oral arguments that were scheduled in April of 2019. The Court of Appeals ultimately affirmed that judgment. Third, Mr. Ogunmeno began representing client PF in June of 2017 in an already pending probate matter involving PF's uncle's estate. Mr. Ogunmeno was advanced $10,000 to perform work in that case. When Mr. Ogunmeno left the country in June of 2018, the probate case was still pending. Mr. Ogunmeno failed to timely respond to PF's request for information about her case and abandoned her as a client. Finally, Mr. Ogunmeno was representing client RCM in 2 criminal cases in Johnson County District Court. The parents of RCM paid Mr. Ogunmeno $12,000 to represent their son. After leaving the country, Mr. Ogunmeno failed to attend motions hearings and a jury trial that was scheduled in August of 2018. Mr. Ogunmeno abandoned RCM as his client, causing delay in his criminal case. The matters I just described resulted in formal charges being instituted against Mr. Ogunmeno and a hearing originally scheduled for March 20th, 2019. On March 4th, Mr. Ogunmeno filed a motion to continue that hearing, noting that he was in Nigeria and not expected to return to the United States until mid-November of 2019. Mr. Augumeno requested that the hearing be scheduled for the first week of December 2019. Based on Mr. Augumeno's request, the hearing panel granted his motion and the hearing was rescheduled for December 5th, 2019. In anticipation of the December 5th hearing, the Disciplinary Administrator's Office filed an amended notice of hearing and an amended formal complaint. In compliance with Supreme Court Rule 215, these pleadings were sent by certified mail to Mr. Augumeno's addresses that he had with attorney registration. The mailings were ultimately returned to the Disciplinary Administrator's Office as undeliverable and unable to forward. In October 2019, this court issued an order administratively suspending Mr. Augumeno for failing to comply with the annual CLE requirements. In November 2019, Mr. Augumeno exchanged emails with former Deputy Disciplinary Administrator Penny Moylan regarding his need to file a motion requesting a continuance of the December 2019 hearing. Despite telling Ms. Moylan he would, Mr. Augumeno never filed a motion requesting a continuance and never provided a current address to the Disciplinary Administrator's Office. Ultimately, Mr. Augumeno failed to attend his disciplinary hearing. After the Disciplinary Administrator's Office put on evidence establishing that he had complied with Supreme Court Rule 215 to achieve service upon Mr. Augumeno, the Disciplinary Administrator's Office put on evidence of Mr. Augumeno's conduct, and at the conclusion of the hearing recommended that he be disbarred. The hearing panel later issued a report on March 23rd, 2020, that Mr. Augumeno's conduct violated 1.1 competence, 1.3 diligence, 1.4 communication, 1.16d termination of representation, 3.1 meritorious claims and contentions, 3.2 failure to expedite litigation, 3.3A3 canter to the tribunal, 3.4C fairness to opposing counsel, 8.1B failure to cooperate in a disciplinary investigation, 8.4C engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, 8.4D engaging in conduct as prejudicial to the administration of justice, Rule 208C failure to notify the clerk of the appellate court of a change of address within 30 days, and Rule 211B failing to file an answer to a formal complaint. Based on these rule violations and several aggravating factors, the hearing panel recommended that Mr. Augumeno be disbarred. Mr. Augumeno ultimately never filed any exceptions to the hearing panel report. Accordingly, the findings are now deemed admitted. Based on the serious misconduct I outlined that resulted in 5 separate disciplinary complaints being docketed against Mr. Augumeno, the Disciplinary Administrator's Office is still recommending that he be disbarred. That concludes my prepared argument for today. I would be more than happy to take any questions from the members of the court regarding this conduct. But again, the Disciplinary Administrator's Office is continuing to recommend that Mr. Augumeno be disbarred.
Are there any questions for Mr. Vogelsberg? Thank you. Mr. Augumeno, you have 15 minutes to address the court if you wish.
Yes, may it please the court. As I speak, I'm still speaking from Nigeria. I've responded to the written responses. I believe they say some of them were late and I requested. At the time, I was sick and I advised who was investigating, but I've submitted all my responses. I believe it's in the record. And I ask that the court review the record, and I commend my responses to the court. I believe the sanction, the disciplinary action administrator is asking for is too extreme, and I ask that my license is already suspended because I did not do registration. While I was in Nigeria, I was sick intermittently, but I'm okay now. I'm still in Nigeria now because I can't return. There is trouble and the airport is closed. But now I'm appearing via video. I'm asking that my license be reinstated, not it's suspended now, but be reinstated. That's all I have, Your Honor. Thank you very much.
All right. We do have the record of the case before us. Are there any questions?
Have you done anything to try to address the legal matters that you abandoned when you left the country?
Well, I have the responses. I've responded to them in my written response. I didn't abandon those cases, but when those things, information were coming in, that was the time I was very sick, and I talked to the client. I think I sent them some emails. Some of the email were attached to my response.
Any
And
other?
the report they said that I didn't respond to. I didn't get the report until I think Friday of this week. Yeah, I know that there was a problem with filing a new address in the United States. But when I went to the website, I didn't get access to it. I couldn't file it. I have to send email at one time. I think that's how they get the new address I supplied to them.
There are other questions? Mr. Vogelsberg, I believe you reserved 2 minutes.
Unless the court has any additional questions for me, I would go ahead and waive rebuttal at this time.
I have a quick question, and it has to do with what we just heard about at least an alleged failure of delivery of what I assume is the hearing report.
I'm sorry, Justice Stiegel. I didn't catch your question. There was a little bit of audio interference.
I'm sorry. I just wanted to get the disciplinary administrator's response to the claim that the hearing report was not received until this week.
The hearing panel report came out on March 23rd, and because of that time with COVID, there was a delay in preparing the record to be submitted to the court. But on April 30th, I can announce this as an officer of the court. On April 30th, my office emailed a copy of the hearing panel report to Mr. Ogunmeno at that time. And then ultimately, this court ordered in June that the 20-day period for Mr. Ogunmeno to file exceptions to the hearing report began to run or start at that time. And within that time period, he never did file any exceptions to the hearing panel report.
And the only way that we can conclude that he had service of the report is from the email. I guess what I'm driving at is whether or not exceptions were filed is pretty significant with respect to whether or not we accept the findings of the panel.
Right. I guess what I would say is Mr. Ogunmeno under Rule 208C had a duty to update attorney registration and provide addresses in which he could be served with pleadings. By his own admission, he had been out of the country for 2 years and he failed to ever update or provide any addresses. And so that was the only addresses that the clerk's office had to serve him with the citation and the hearing panel report. Again, on April 30th, my office did serve him, or I mean, as best as we could. The only way that we had information that we could reach him was through a Yahoo email address. That's in the record, I believe, at exhibits 33, 50, and 51. There's evidence that he was using this Yahoo email address to contact Ms. Moylan and talk to her. And that was back in October of 2019. And that was the only way that we had to communicate with him. And so on April 30th, that was how we served the hearing panel report, was through that email address.
From the perspective of your office, is there any merit in the idea that now that we have Mr. Ogunmeno with us, he could be provided an opportunity to make a response to the hearing panel report?
I believe he's already had that opportunity. What he could have done during the 20-day exceptions, which he did receive notice of, is that he could have requested an extension of the deadline for filing.
I guess cutting to the chase, your office would oppose any such suggestion.
Yes.
There are other questions? Okay, I would thank both of you for your arguments. The court will take this case under advisement. That brings us now to the hearing of our next case in 112332.
Madam Chief Justice, we will get the attorneys into the hearing.